We are live. All right. Here we go. Let's hit it. All right. Don't have anybody watching, that's fine. We'll get it on replay. Okay, get this comfortable. All right, what I am going to discuss today. First off, I haven't done a video in quite some time, so there's that. And the reason for that is I've been incredibly busy in my son's case. So I haven't done a video, I think, since before the beginning of the year or around thereabouts. So I don't know, honestly, if I've done a video telling everyone about what we did on January 6th, which was we laid a special form of habeas in my son's case in the district court, bankruptcy court for the District of Columbia, and filed a habeas under a special admiralty jurisdiction where they proceeded to violate lots of laws and statutes and make us, literally denied us filing a habeas in the district court clerkship, which is a shared clerkship between the District Court of DC, which used to be the Supreme Court of DC till it was morphed into the district court for the District of Columbia post-Reconstruction. So the district court clerkship for the District of Columbia is the old Supreme Court for the District of Columbia pre-Reconstruction. And that was then split after all the bankruptcies into the DC Bankruptcy Court. They have a shared clerkship, same clerk, controls both desks, both clearinghouses. And the problem with what they did is they basically proved that you have to be a debtor to lay any pleading in bankruptcy. So that imparts that someone is always the creditor and that you and I are always debtors. Well, that's not equity. In fact, that would impart that the 14th Amendment clause, where all clauses will be paid without controversy, only impart to some secret body that apparently got it all figured out with no names included, that they were always going to get paid when they brought claims. But if we brought claims against the states in bankruptcy, which they are, who have issued patents, birth certificates, Social Security card benefits, and all these negotiable instruments upon those bankruptcies, if you go to bankruptcy, they're going to block your filing unless you come as a debtor. Well, my son is not a debtor. He has never been a debtor. He will never be a debtor. You can't make children debtors. So in that regard, when we went to do that, and they denied us filing him as a person non compos mentis, who should not be a debtor at the age of 7, which is what he is now, for being seized by instruments created within the bankruptcy platform, the birth certificates and the Social Security numbers through the title programs. We were blocked. And not only did they block us, but they obstructed us filing it for so long. Practice law from the clerk seat promoted the the profession of esquire, which is a high misdemeanor by de jure statutes from 1812, and denied us filing it on the bankruptcy side, even when we proffered what they said, well, we need a case filing from a bankruptcy. I said, okay, well, here's the probate case number from when they seized my son, right? Oh, they freaked out. So in any case, we were made to go to just literally take a step over, talking to the same people. Would you like to be in the district court now? But by the time they decided they would take it somewhere where it had already been, who had said they didn't have jurisdiction, and thus by principle of estoppel and pass, it couldn't go back to that shared clerkship. It should be over here, proper side of the court. We were made to go to the wrong side of the court. By the time they did that, the clerk window, the bank to take money, had closed. So we drove all the way to Ohio to file a habeas on my son in the federal district court, and we were barred from doing that. So they're done in that regard. Okay. We were then made to go to the wrong side of the pleading, back to a court who had said it did not have jurisdiction because they wanted to impose immunities from state actors. Well, the de jure states are not immune from lien. They're for corporate fictions laid over them in bankruptcy by foreign patented instruments of esquires are not exempt from lien for frauds as trustees. Okay, so the presumption and this averment of a doctrine, even under parent patriae, which has already been affirmed, that if you are, the state cannot affirm parens patriae in a cause of action where it has a pecuniary interest and or the property it has lien to or claim to. So all these child custody cases are totally criminally being adjudicated, even under the statutes, because and the existing case law from 1969, by the way, because it clearly states that states cannot be the parents and adjudicate cases where they are a party of interest, benefit from the cause of action, get funding. Regardless, what has happened is my son's case, we went ahead and docketed in the mail back door. So we stamped our own case. And we put it in the proper post pleading, the bankruptcy slot. If you've ever been there, there's a bankruptcy slot and a District of Columbia slot. Now it's shared clerkship, but one's the bankruptcy court, one's just the DC District Court. Well, we put it where it was supposed to be, even though they refused it up front. We went to the backside, stamped it, and it's a shared clerk stamp, folks. Okay, so it's like either or. We put it in the slot for the bankruptcy where it went, and again, the clerks obstructed the law and refused to properly docket it, and sent it back to the District Court of District of Columbia. We had gone through the whole circuit system to prove it did not have jurisdiction. That they were all agreeing that they didn't have jurisdiction, that states are immune from torts against people. I mean, where they get this law, other than they don't read the Constitution at all, is beyond my comprehension, other than attorneys are mandated to just, okay, because you say, and I'm a Bar Guild member and I won't work the rest of my life and I'll have my retirement, all these things. My family will be threatened, whatever else they do. But I went ahead and proved that they were basically operating under a doctrine that's unconstitutional, and in the process proved that they're in a fifth jurisdiction and all these other things. So in their fifth jurisdiction, extra constitutional, they just think they're immune from all things, and the states just, there's these insular entities that they just do whatever they want, their agents can do whatever they want, and they're immune. And the federal government has no authority when it comes to states operating openly unconstitutional and fascist tyranny with foreign agents running around seizing children with no warrants. We just have no jurisdiction. This is what the district courts and the federal circuit and the District Court of Appeals have said. So we go to the bankruptcy, mind you. I'm doing a little figure eight. I'm taking out all the courts of the district who are openly violating the Constitution in their rulings, with obfuscation of terms, and this belongs in the Supreme Court of the United States. I'm like, yeah, I know. I told you where that is. And it ain't the Supreme Court. SCOTUS created post-Reconstruction. That's a fiction of statute. Ergo, an Article 3 court. So it ain't SCOTUS. I know where the Supreme Court is. It's called the American people, which I invoked in this habeas, literally in the title. An Article 3 Supreme Court, which is a common law court, is invoked. I did not go with a petition for writ of habeas. I went with an order of a writ of habeas. And within that order, if anyone would like to follow the law, there are 2 warrants for the seizure of the vessels of my 2 children, which is what your body is. It's a titled vessel. Mandated under Title I, where they mandated that everything that come to this land, all vessels to this land, must be given a license or registration with certain things. So I ordered through the writs of, because all the courts over here said we don't have jurisdiction. In our opinion, states are immune. Well, we know that by law they are not, and by Constitution they are not. Sometimes I challenge their bankruptcy presumption that these states are immune, because they just proved that the people are getting paid without controversy are the corporate fictitious bar union coup overlay states, which are mere fictions of law that are just stealing everything you do. And that's what basically I just proved, that the whole system is a fraud. Okay. And if you remember correctly, I had been talking about how I know that they're running around with this instrument that I never got back from this clerk of the Federal Circuit, the District of Columbia. Now the Federal Court of Appeals for the Federal Circuit is what it is. So that court, you have to understand, DC has kind of 2 pillars. They have a statutory pillar and an equity pillar. Pardon me, turn this off. And the statutory pillar would go, you come into the District Court of DC and you lay your claim there, and then on appeal you go to the Federal Court of Appeal, the District Court of Appeals for the District of Columbia. And then above that, if you chose to go to the highest statutory court, which is not SCOTUS, the highest statutory court is the last one created, the Federal Court of Appeals for the District of Columbia. So it's the Court of Appeals for the District of Columbia, District Circuit. Okay, it's the federal circuit, the federal statutory court system, and they're supposed to. The District Court of Appeals is mandated by the creation to be the people who are supposed to tell the executive branch how to bring statutes into compliance with the Constitution. So that's where you'd go if you can prove that Title IV is totally unregulated except by the judiciary, and that they're stealing babies without any foreign oversight or federal oversight, all these other things. That's who you take it to. Well, then there's also the equity court, which they like to bar us from because they don't want you to know that your birth certificate and your social security numbers are instruments of equity. But then again, and I'll just show you this real quick. Okay, studio mode. Display captures what we want to go to. Okay, here. Okay, here is what United States Court of Appeals for the Federal Circuit. Okay, this is the Title 28. Make sure I'm in capture. Yep. Okay. Title 28, U.S. Code 1295, Jurisdiction United States Court of Appeals for the Federal Circuit. This is the equity side of the district courts, the District of Columbia courts, and it says that it shall have exclusive jurisdiction. And you only need to read A of an appeal from a final decision of a district court of the United States, the District Court of Guam, the District Court of the Virgin Islands, or the District Court of the Northern Mariana Islands, in any civil action arising under, or in any civil action in which a party has asserted a compulsory counterclaim arising under any act of Congress relating to patents or plant variety protection. Okay, so now you know who is the court with jurisdiction over all things patents. And Title 18, I've gone over in previous videos where the statutes internally tell you that everything related to patents is within the jurisdiction of District of Columbia. Okay, so here's the principal cause of action for everybody dealing with land patent foreclosures. If the federal statutes say that all things related to patents are within the jurisdiction of the District of Columbia, and the exclusive jurisdiction in all things related to patents and or appeals and or claims against them are in the Federal Court of Appeals in the District of Columbia, how are county courts laying a lien as though they control any aspect of a federal patented instrument leveraged with the Treasury called a mortgage title, a land patent? How are they exercising jurisdiction over instruments specifically within the jurisdiction of the District of Columbia? And therein lies the basic coup of all that is the United States coup. Okay, and all things related to Treasury, in that you don't know where the jurisdiction of the instruments lie versus the jurisdiction of the people saying they have control over them. If you knew the jurisdictions of where the instruments lie pursuant to the laws and statutes versus where they're imposing jurisdiction over them, you would see that it's a prima facie fraud, and all things would fall apart. Well, and that's been proven now. So the purpose for this video was to catch you up on what's going on with my son's case. After we laid this on the 6th, we're obstructed, of course, just at the very end of the month. They said again that they don't have jurisdiction on this case, and that the Rucker-Feldman applies in this, meaning state actors are immune, which they aren't, again, because you made money. Okay, we'll let you kidnap for money and say you're immune. That's what the Fed courts have done. So mind you, the biggest error here is in the clerk. In this case, the clerk committed a fatal error, and our reply that was just sent out recently brings those fatal errors to bear, because the clerk committed a variety of fatal errors, including operating in criminality pursuant to specific statutes, and the blocking of the case, of the filing, and all these other things. And also in the manner, specifically, what you're going to learn has to do with the gloss, which we talk about, the people in, quote, common law. And the constitutional law talk a lot about gloss, if they know anything. And I'm going to show you now how what's going on in the past week has to do with my son when it comes to the stock market crashing today within 15 minutes. The highest number of loss within a short period of time, I think, ever in the history of the stock market happened today. And they were open for 15 minutes and crashed 2,000 points, and they pulled the plug. I'm going to tell you why. And that's because since I have laid this stuff in the 6th, I found some things happened. And remember, and I said, someone's walking around with this instrument that's very important called a lis pendens, which is an averment or a claim of lien upon something of a negotiable instrument. Status. Okay, so something which has an inherent value, when you want to say you have a principal interest in it and of any kind in it, you create a lis pendens on it. And in the lis pendens that I created, I laid together the birth certificate and the social security numbers together for 4 instruments, my wife's and both of our children's social security numbers, which have all been defrauded in the cause of actions through the court systems themselves, because the perpetuation of kidnapping is a crime as much as a kidnapping. So when you go to a federal circuit judge, quote unquote, and it is completely unlawful to do what they're doing within the states, and they decide that they're going to mandate this doctrine of their guild, not in compliance with the law, that perpetuates the kidnapping. Okay, and you clearly prove that they're not in compliance with the law by statute within your arguments, and it's sitting there and all these things. And or when the District Court of Appeals for the district circuit accepts your statements of facts as the facts of the case, which state all the facts of how they're violating the statutes and the law, even in their adjudications, those acts by trustees, okay, become criminal acts that perpetuate kidnapping. Okay, so everybody's got their hands on my son's case, and any instrument thereof are up for kidnapping as a treasury crime and the perpetuation of kidnapping as a treasury crime. We're not counting just all the other stuff. Conspiracy, sedition, treason, RICO. We're just talking about anybody who has touched my son's case that has not followed the ens legis statutes to a T, are up for perpetuation of kidnapping, which is a treasury crime as much as kidnapping is a treasury crime. They can say that there's no crime in Title 18, but under the treasury statutes, it says kidnapping is a crime. So they may not think themselves criminal. The treasury considers them criminals. So regardless of what this private bar union fifth commercial jurisdiction these criminals affected in 1940 before World War II, which now in the Havana Acts of 1940 and the subsequent executive order acts that happened after that, which happened before World War II, okay, which means that they plan to use this fifth jurisdiction to traffic the people in Germany, folks, okay. So that means that what they did in this fifth jurisdiction, they set it up before they started stealing babies and people and disappearing them from all over Europe. That's the American attorneys and the American system of treasury and stuff commingling with all the international conspirators in the bar union guilds that had been co-opted and in coup through the Masonic order since, well, I don't know, they've always been polluted. It's just how many of them were good guys of honor or not, and who their fealty truly was. And that's really the problem with Esquires. Their fealty lies to whoever their master is, who holds their patent or their instrument of commerce, like the hat that they put on. You have to think of these things as hats, as masks. Think of them as like hats. So their ability to access and even be what they're doing for a living is held by the Queen and the Pope. It's called a patent, and they can remove it from them at will. They don't have to. It's not like they go, "Oh, well, you took my license to practice law away." There is no review for that, except other attorneys who have to agree. Well, you better apply to what we say, And you've even just seen that in a video that was just brought forth when the schmuck went before the Supreme Court with a crowd of people and threatened them with seemingly violent language. That when you heard that on the floor, I think Mitch McConnell was making a speech about how the Democratic Judiciary Committee from the House had sent a letter to the administrative court saying, if you don't start adjudicating cases pursuant to what we think the statute should be read as, that we're going to defund you and just reorganize you and deconstruct, okay, that's one of the problems with administrative courts as a tool of coup by political. That's by the fact that that letter would be an act of conspiracy to undermine the laws of the United States. I'm going to go over the definition of treason real quick, but you're being exposed to the fact that these people are just openly acting in treason and sedition, void of any law, because they just think that we're just immune, because all attorneys are immune in our little secret little thing, and we can say what we want. They think if they say it is in the law, and that's not the law. Unfortunately for us, that's not how it works. So when they say that, the states are immune, that as a doctrine, that doesn't fly in the establishment of all that we hold holy in the law. And just because every court in their private fifth jurisdiction, which I've proven to be a private fifth jurisdiction created unconstitutionally, outside any purview of, it's a far stretch even under executive privilege. But more importantly, what I've proven is that the United States government conspired with the imposition of Lex Mercatoria and moving all things Treasury into this fifth jurisdiction prior to World War II, that they had something to do with the Nazis moving people about and stealing babies and killing people and seizing of land. And you're going to find that out, folks, that the hands of the United States government, and I've spoken of this, if you know anything about the history of the United States, prior to World War II, the KKK held its national meetings in Madison Square Garden, folks. Madison Square Garden, to the tune of 35,000, 45,000 KKK members saluting with the red Hitler neo-Nazi stuff with their little black guard. That they had a special black guard that were basically the SS that were sheriffs and stuff, folks. So prior to our joining the World War II, where we're enemies of Germany and the fascists, which there's 45,000 at any one yearly meeting of the KKK. As I tell you, there's a reason the quote common law was taken away from the way the United States was cultivating prior to World War I and II for a reason. Okay, it really was, because they were white supremacist Nazis that had couped the government in key instruments, and it wasn't the American people at large. It was just key people even then. So here's 45,000 people that show up, the year before we go into World War II, and we hate fascists and Nazis because of Pearl Harbor, which we now know they knew about. So you have a president that enacts the Havana Acts and slides everything into a fifth criminal jurisdiction, private jurisdiction under, quote, British Lex Mercatoria, commingled with American Admiralty and all this other stuff, and put everybody in the world under this world trust where only the POTUS and the Attorney General's in charge of the commercial law, which means that that when you remember how they brought everyone in paperclip? Well, they wouldn't commingled commerce with them already during the war. So the United States government, which would be specifically POTUS at the time, and or the Attorney General, just by his own regard, because he had complete control over, which even now, with POTUS, Trump admittedly being unlearned in the law, don't do legal, he's a ward of the Attorney General. So you have a POTUS who, by legal standards, doesn't even have to be told what the Attorney General's doing, because he's so learned in the law he wouldn't know what I'm doing anyway. So you have an incompetent, vacant POTUS that, under the Havana Acts, is just this instrument of face and bark and be going around doing what he's doing. I'm telling you, he is going around doing whatever he wants to do. And that's what kind of this video is about, as to why the market crashed 2,000 points within 15 minutes, because they've been found out. And I found them out after we did all this stuff with my son's habeas and got totally criminalized by the clerk there, by the clerkship in general. Because, people came, you guys, you should see, I wish I could videotape these still, but used to, we'd come in and they just come out in hordes from the back and just start attacking you. And there was one, my wife was there, she's like, I think I just saw something divine. I was like, you did. You saw a bunch of people conspire just kind of organically against what we were doing. And she was like, yeah, I got that. It was creepy. And it really is creepy to see that ooze of just inherent evil lawlessness and obstructionism come into your purview. But I mean, I'm kind of used to that, and a lot of people shrink from that, and that's why they can't really keep going, because they just you get hammered and insulted and defamed and impugned. I mean, you go into a clerk, and they do. And there was actually an attorney that they kicked out because, again, we were speaking and arguing with these people on how to docket something that we should have just been able to walk in for like 30-40 minutes, and there was an attorney there that they forcibly made her leave because she was witnessing what they were saying, and her eyes were just like getting huge, right? So, because even attorneys, when they hear what's going on, they're offended too. I mean, there are good attorneys out there, folks. You know, probably the majority of them are good. I know that most of them have no idea what the hell I talk about half the time, and that's fine. That's how they're programmed. They're just supposed to stamp instruments, except they don't even know that they're the stampers of instruments. They don't know anything about what they do. So regardless, since that time, found out that they did use my negotiable instrument, and they used it here, and I'm going to show you how. They discovered that they have reorganized the Fed. They've paid off, JP Morgan paid off all of its tax due bill. I'm not going to go into the I'm going to do an extensive video on this because it's part of the ongoing case. But what they basically have done is they took my son's Les Pendens. Remember, it was in case 19-1099, which I noted it. I thought, oh, that's interesting. They gave it a 1099. And mind you, this was at the beginning of the year. They would have had to jump ahead in the numbering to give it a 1099. Regardless, they used that 1099 basically and stole the instrument. Because mind you, I never got it back from the clerk, and it's a wet instrument, folks. It's by my hand, my wet instrument of a lien upon the Treasury. And I have other instruments showing that I hold the lien on the Treasury, and I'm the sole settler of this particular case. But they took that wet instrument and then amortized it on the back door, and paid off like $104 billion in debt in the state of Ohio. And the Fed now is running out of the state of Ohio under a fiction called Christopher Eric Fite, LLC, which is an entity of the District of Columbia under SEC registration. So I have done a lot of research on this. The extended video will be going over, well, at this point in time, I think I have 11 pages of instrument. Every date on here is a date of a state instrument proving this extensive fraud, where they flipped instruments from Puerto Rico case to here and this, and then came to the state of Ohio and leaned the Republic state, the state of Ohio, and now presume as an entity, as an address. I mean, you should see the stuff. You'd have to understand the Ghost Instrument law just to really feel the full effect of the offense of what they've done. But basically, the Fed is now Fed Fight Fiction, registered as an entity in the state of Ohio as a domestic charter, registered in the District of Columbia as Stark government. I mean, it's all this crazy shit. So the reason why, okay, in learning all this, I produced this little letter, which is titled Letter of Rogatory in reference to Notice of Fiduciary Duty pursuant to CFR 17, subsection 200.800 and 230.500. And we'll get over what this is about. But basically, I took all these instruments, and I can the instrument where I saw this was someone had put somewhere some documents showing the JP Morgan Chase related to some guy, Fed Fight Fiction and Holding Company. And I went from that, and I have inches of state documents where I've pulled all of the activity of all the associated instruments, and distilled it into a very seven exhibit letter to the IRS, the SEC. Let's see who's on here as fiduciaries. This letter was sent to the U.S. Securities and Exchange Commission, Office of Comptroller, the Currency Chief Counsel's Office, Jonathan Gould. The Securities and Exchange Commission is Tracy L. McNeil. Department of Insurance, Securities and Banking, Theodore Miles. And Theodore Miles was very helpful in this. He actually showed me some cases in D.C. So that guy's he was excited to send me that. I'm going to tell you that right now. So yay, Theodore Miles. Kudos for him. United States Army Intelligence and Security Command in Beulah. And these are, the important significance is that there's 3 to military personnel, because this is now a matter of national security under the DOD. All of this, my son's whole case. Chairman of the Joint Chiefs of Staff, that'd be Mark Miley. United States Department of Transportation, Ellen Chow, I know, I butcher sometimes those names. United States Department of Agriculture, Sonny Perdue. Department of Defense, Mark Esper. United States Office of Legal Affairs. And that's where you would send information if you were operating as a conservator of the estates of the United States, which I am, because I'm here to preserve our republic, because they're stealing us blind and stealing our children and selling them. The State of Ohio Division of Securities with an Andrea Scheit, who that did not meet. You'll find they interfere with service all the time, either by losing stuff as the postmaster, just losing it for 7-10 days, and in some cases there's some that are still missing, and delaying service and stuff like that, or moving the ports. Like, we don't deliver to real Fed offices, we just deliver to a post. Why am I paying $9 to have the postman deliver it to a woman in a federal building, and I'm only getting it delivered to the back door of the general post of the federal building? So again, seizing ports, obfuscating port access, these are all things that are the criminal RICO that the government is regularly involved in, or agents of the government, not the whole government. But it doesn't take that many in key positions to do what they're doing here, folks. Really doesn't. It takes a very small group, a couple hundred, maybe 3. Anyway, and also then the Internal Revenue Service Office of Chief Counsel. Now I'm going to read this letter to you, and I'm going to actually read it as I show it to you in a PDF format. So, because I know that's easier for some people to do that. And this is a fairly important, let's get 100% here so I can see when I do it. Okay. So this was sent out the 27th. And the really cool part of this is that, first off, let me give you a review of what this CFR, and these are related to what we're going to review to be, well, I might go do that real quick. 17 CFR pertains to using certain control numbers, OMB numbers, okay? And OMB numbers have to do Office of Management, and budget, okay? So in this one, we're going to specifically be talking about, I believe, 800. I think it's 246. Regardless, the one that we're looking at is 230.50. Let's see which section it is. Here, we're going to be in this one, Regulation D, Form Ds, and this OMB number 32350076. These are numbers that are on securities and exchange forms, folks. These OMB numbers will be at the top of different types of security exchange forms and securitized instrument forms. Well, what we're going to be talking about in this case is things through Regulation D, Form Ds of Securities and Exchange. Okay, use of Regulation D. The significance of Regulation D is that you will see that Regulation D, these CFRs in general, these are all under the Department of Defense. Okay, these are all under Department of Defense securities. Okay. They are regulated by Title 17 CFR is a Department of Defense controlled instrument. Okay. In particular, the section we're going to talk about, you will see here, they are not exempt from anti-fraud, civil liability, or other provisions of federal securities laws. Now, the significance of this section in Form D is this is the type of form that they fill out when they're wanting to get paid without controversy, and we will show that in a moment. But I wanted to review what this letter of rogatory is pertaining to, making sure we're getting that, making sure we don't have any weird audio playing. Okay, I think we're good. Okay. Yep, okay, we're good on the sound. Go back to, here we go. All right. So this is a letter of rogatory that has been written to all of those addressees that I listed. Where's the whole instrument? Just a moment. I'm going to pull up the whole instrument that is supposed to be in here. Give me a moment, and I will do that. Okay. There it is. Because it was only bringing up 7 pages instead of all 49. Okay. All right. Here we go. Back to video so you guys can read along while I read. Okay, this is a letter to all these important SEC people concerning some activities that occurred here in the state of Ohio. Then you'll see what they are because I'll go through the exhibits. Please be advised that as counsel for the relators in case number 19-1099 with the District Court of Appeals Federal Circuit, case number 18-5369 with the District Court of Appeals District of Columbia et al., I have conveyed the following information to the Department of Insurance, Securities and Banking in Washington and the District of Columbia, hereafter Washington, D.C. See Exhibit A. Okay, let me get to Exhibit A. I don't know why we'll do it continuous. Exhibit A. Exhibit A is an email that I sent to the young man in D.C. Under the Securities and Exchange Commission. And it was in response to, I come to find out that in doing this research that this young individual, Christopher Fife, Eric Fite, you can see it right here, that Christopher Eric Fite had already been involved in a default judgment in the District of Columbia in the use of this instrument. And he sent me all the associated paperwork. So my reply to him after reviewing the associated paperwork and having researched more on this entity that was operating now in the state of Ohio in conjunction with JP Morgan Chase and the Federal Reserve Bank, that this was no longer a state of Ohio. He referred me to state of Ohio securities. I said it's not because now we're engaged in treasury fraud. So I proved that on the February 25th, I communicated back with Mr. Theodore, right here, Theodore Miles, as to what was going on in Ohio and the use of this instrument, and saying that though he had referred me to the securities, which I did call the Ohio Securities Office, I never got a call back from him. I have yet to get a call back from him, probably because they've been served this right now. But the point being is it's no longer in the state of Ohio's jurisdiction. This is now a federal securities fraud jurisdiction. And in as much as the form that he used is Form D, this instrument was already declared void in default and not in proper standing to offer securities as a bank. This is now in the DOD. So this is Department of Defense. Here we've been trying to get something to the Department of Defense for, at least for me, for 10 years. I've been trying to get proof of, I've been trying to get evidence of treason and sedition, which is prima facie all over the courts, to the district, to the provost, to the Department of Defense, and also, and here these people with their activities backdoor with instruments from my son's case walk themselves right through the eye of the needle, right into the land in a DOD fraud upon the Treasury case with an instrument that's already in default in the District of Columbia. So either this guy's exceptionally stupid, or again, they're so full of hubris and apostasy and think they're immune. They just do whatever they want to do and think they're never going to get caught. Okay, well, they got caught, like, big time. They're totally gone. I don't even have, this is a prima facie instrument case. You don't even have, there's no arguing what's gone on here. These people are going down for treasury fraud. And since it's associated with my son's case, you're now talking about tangential treason. Because remember, treason is tangential. So you're talking acts of treason concerning the kidnapping of a child by a state actors in conspiracy against substantial rights and to traffic him as an instrument and a commodity. And all these people enjoined to that. And now you got them taking an instrument within that I cured. Basically, they tried to steal 10 years of my intellectual property is what that one instrument was, folks. They tried to steal my intellectual property, which is what they do all the time, right? That's why they're here. They're here to steal everything that is our capita. So they thought they'd take 10 years of my work in law and the courts and all my and just take this one instrument and just do with it what they wanted to, and then pay the state of Ohio for kidnapping my son, which is basically what they did. So the state of Ohio got rewarded not only in Title IV funding, but in bringing the Fed here, reorganizing as this fiction, this Fed fight fiction, which FFF 666. How funny is that, right? That has seized all these instruments up and then brought them criminally to the state of Ohio. I mean, you couldn't ask for more divine. Hey, thank you, God, for seizing all the fish up in one net and bringing them to me. Thank you very much. So let's go back to this little factoid here of law that has been created. So that's me basically saying I've already communicated this claim to the District of Columbia's Securities and Exchange Court. DC has their own courts, folks, too. Okay, city courts. But they still have jurisdiction over things that are within the jurisdiction of District of Columbia, such as patents and securities and exchange instruments. So, wherefore I affirm and aver and assert that the name that said notary notice of fiduciary duty pursuant to CFR 17-230.50 to the addressees as stated herein concerning the same said frauds upon the American people, citing Barron v. Baltimore, Sustake Trust, and the Sustake Vi derived therefrom. A Les Pens under wedding signature, sorry, excuse me, skipping very quickly here. A Les Pens under wedding seal and signature laying lien upon 4 Social Security trust accounts as adjoined to their 4 respective land patent certificates of live birth, see Exhibit B and C, and we'll go over that in a minute, as 11 total pages and certificate of interest as 4 total pages respectively attached as if fully rewritten herein, as laid in claims upon the bar of equity in case 10-19-1099 with United States Court of Appeals for the Federal Circuit, hereafter Fed Cert. Okay. As initiated 10/22/2018, was unlawfully seized, stolen by, from, never returned from, etc., the clerk of Fed Circuit to my care, custody, and control, and was subsequently utilized by the entity, the fictional thing, Christopher Eric Fite, as registered within the jurisdictional boundaries of the District of Columbia. As such fraudulent actions lay within the jurisdiction of the agents operating therein and not within agencies operating within the territorial states, such as the Department of Defense, hereafter DOD, United States Securities and Exchange Commission, hereafter SEC, and or Washington, D.C., etc. So basically, none of this in my son's case, or anything related to patent fraud, folks, which is all fraud occurring in the world now, are all under the Fed Circuit Court and the agencies in the District of Columbia. The state tertiary administrative bodies have no jurisdiction in this matter by law, except that they're operating in this 5th private jurisdiction where they commingle all the jurisdictions, and foreign agents of a federal nature, international nature, are operating in the county as though they're your county government. Okay? You need to understand these things. This is all fraud. Whereof the entity Christopher Eric Fite, as registered under the Securities and Exchange Commission, Form DA, Exhibit D, as page 1 attached, operating as the fiction out of the state of Ohio since 6/2019, appears to be a fictitious pass-through entity for a now reorganized and remonetized Federal Reserve banking system, hereafter Fed. Let me go to D. Let's go over the Les Pens. I've not that you can't get all this information online. If you go to Pacer, your access to this information and all that's in it will be tracked because it's sensitive financially and national security. So just so you know, you will be tracked if you pull this off Pacer or you even go look at it on Pacer. And I'll be tracking who looked at it. Okay, so this was the copy of the Les Pens that was filed on the 14th of December 2018. What's important about the time of this is when I go into the extended explanation of this instrument and how and why it was seized, is at the time of this a order from the clerk, where the clerk actually operated as a law without a license, because as it reads, the clerk issued the order. Regardless, we went to the Federal Court of Appeals and asked them under a merit review where this case was owed, and they said, well, we only hear cases concerning patents, and this is a child custody case. Therefore, we're just going to say it goes to the Federal Court of Appeals for the District Circuit. And unless you say something in 14 days, that's where it's going to go. Well, we waited 14 days and no mandate was issued. None. So then, because I'm going to go with their opinion, so then I waited another 14 days and still nothing. So basically, I waited 28 days for them to issue the mandate, which they didn't do because it would have been criminal. And then waited another 14 days to cure that lapse of the correction and created and issued this Les Pens and laid it up on the bar. And as soon as we laid this Les Pens up on the bar, they issued the mandate. Okay, folks. And that's when it gets really interesting in what happens in the state of Ohio around this time frame. Regardless, this is a Les Pens. And you will see that there's some significant language in here. It talks about fourth crown claim on equity for breach of contract and the bringing of false claims against the United States of America for failing in their fiduciary duty under repository trust law and equity as the imposed trustees of our de jure allodial United States. And it speaks down here of that these are the civilly mortis status. These are the United States placed into civilly mortis status on behalf of the American people under Sustake Trust. This is what the TONA did, folks. This is why the passage of the TONA is a very important thing for them to obfuscate, because that makes them trustees instead of your government. And trustees are liable for their personal frauds against their trustors. So they had to get rid of the TONA so that you all would understand. You all would think they're your government when they're really not. They are internationally imposed trustees, and at this point they are criminal trustees, and they have been criminally operating for hundreds of years, actually. So regardless, as they are the express and implied trust of the nature of provoso, I mean nature of contract. And this is all about contract, folks. This is all contract fraud that they never wanted us to catch them in, and they've been running away from the contract fraud and away from the hiding and the obfuscation of the facts of law that prove the contract fraud until they couldn't run away anymore, because the internet came and we have the ability to do research, and we can look at things in more of a fifth dimensional aspect. So the importance is that it's for the failure to abide by the terms of the Treaty of Peace and the Treaty of Amity and Peace. Okay, that puts us back to 1776. That puts us back into frauds upon the Northwest Ordinance and the terms used therein, such as United States citizen, being in Section 9 of the Northwest Ordinance, which is a landed holder of a certain tract of land for more than a period of 3 years. Okay. Remember, my son was not taken until he was after 3 years, so he had held his land for 3 years as a Northwest Ordinance United States citizen, folks. And he had rights under the law, under that de jure construct. And even before that, as his name, bloodlight right, Croy, is an independent name. He has a blood right, heir to be free. So these are all, they made the mistake and picked the wrong people and the wrong people to mess with. But what you'll see I've done here is I list the 4 of them, and I've redacted them appropriately, but you'll see that the format is basically is the property to which, okay, these are to property, okay. The Social Security number as an instrument of negotiation, as any and all things originating tax parcel land patents and or negotiable instruments and or foreign bills of exchange and or derivatives therefrom thereof associated with the Ohio Department of Vital Birth Certificate of Live Birth number filed upon in the said name on a certain day in the year of our Savior. So you're basically putting the birth certificate with the Social Security. Now, this is the form for filing a fourth crown list pins that will be put out, because they're gonna be curing our instruments, and they should be able to put these together. The question is whether they're putting all of what they've derivatized against you together, because the CUSIP numbers are also being defrauded as well, because CUSIPs are supposed to be engaged in all derivatives created under the Social Security, including marriage names, changes. If you get a secondary Social Security number issued, there's another CUSIP for that. Should be a sub account for that, and also case numbers. And so the people providing you CUSIP numbers, they're also on the hook in this case too, because we used a regular one that a lot of people use, who are of a questionable nature and source. And now that those people have access to CUSIPs of these Social Security numbers that are under DOD, we have every ability to now go and audit what they've been doing for the however many years they've been defrauding people, stealing stuff by accessing their CUSIP numbers and not conveying them their total values and stuff. It's the same way they're just pirating. They're pirating what we're giving, what they're doing, folks. Everything they do is piracy, really. And it wouldn't be a problem, except they're not pirates to our benefit. They're pirates for other people. So again, so we're laying these in claims of equity for unlawfully seized, stolen by, from, never returned from. Okay, so here we are, Form D. Okay, now we're going to go to Form D, which is after the les pins. And here's a certificate of interest. These are important, very important to do, because this is where you actually create counterclaim instruments. Okay, see this one right here, this R. Exton Lotus Justice. See that all capital? This will come up here shortly. This right here. Pay attention to that. Okay, that's an instrument I created. Okay, I created that instrument. That's mine. That's of mine. And again, this is not their form. I recreated. I never use their forms. You should never use their forms. This is saying it's in satisfaction of this form, and I'm answering the answers appropriately. No parent are recognized or known to have any stock in any party of interest. So I'm basically challenging by this right here everything under presumption under the Habana Acts and everything else. Let's reverse that right there. There we go. So now we're going to go to, this is proof of receipt. Okay. Here's the SEC address of Christopher Eric Fite, LLC, 3715559. He incorporated, he's got a mailing address here of Old San Juan. And guess what? You'll find out later that he is a party of the current attempt to bankrupt the Commonwealth of San Juan by bringing a bankruptcy against all the attorneys that have ran it into the ground under the direct supervision of the FBI. So interesting that this guy, this instrument here, is also a party of interest in that. So now they're kind of screwed in that regard, because now they have an agent of international treason, sedition, in an attempt to steal our treasury, engaged in as a real party of interest in the Puerto Rico Commonwealth bankruptcy, which I can tell you makes no sense. Puerto Rico is managed directly by the FBI folks. Anybody who tells you otherwise is lying to you. Okay, so whatever's going on in Puerto Rico, when they talk about the governor this, no, that's the FBI. The FBI directly manages Puerto Rico. It has managed Puerto Rico since it has become a booty of war under Truman. So anything related to Puerto Rico is RICO. It's called the Port of Rico for a reason, folks. Okay, and that's because they do all their international slushing in the Puerto Rico courts, and that the Puerto Rico courts are also enjoined in the activities that have gone on in the state of Ohio too. They brought a Puerto Rico case into paperwork. What they do is they just took a couple pages out of this case and stuck it in Ohio. And that's what they do. They just flip instruments around and commingle things to obstruct the fact, the law, and to tort the title, to cloud the titles of things. That's what they're experts in, is clouding titles by the theft of instruments. And that's what the kings of the temple of the rubble temples are. They're just they seize things in trover and act like they're theirs, and continue on like they made it and they created it. They seize things and twist the titles. So, such as all of your allodial states, which are yours. They tried to hide from you that they're just trustees and you're owed them by law. They think that you should be getting them at fractional siphoning while their elite masters live off the volume of our equity. And that's really what's happening. So in any case, let's get back to this. So it's a stolen instrument transacted. Okay. Wherefore, the remonetization of the Fed appears to have utilized a stolen negotiable instrument, the Les Pins, in case 1099 with Fed cert as reference, transacted as a 1099 through H&R Block to the Internal Revenue Service on behalf of J.P. Morgan Chase. See Exhibit E, State Ohio document, and this is the case 20172. If you go to the State of Ohio document, Secretary of State document search, and put in 201-722-101-438, you and or look up State of Ohio certificate number 3888559. You'll see this instrument, but I'm going to show it to you in a second. But with a Christopher Eric Fite holding the receipt of the Federal Reserve Bank of Fite & Co. Holdings, hereafter Fed Fite Fiction, under by the Board of Governors for the Federal Reserve System, 180 East Broad Street, Columbus, Ohio 43215. So I'm going to show you the instrument that the Fed Fite guy, E and F. And so you can see, pass this. That's PIN, certificate of interest. There's the filer. Okay, here is the receipt for the state instrument, and you'll notice that it's attention J.P. Morgan Chase NA 180 East Broad Street, Continental Plaza, Tierra Fund. Look, here's the Christopher Eric Fite LLC. That's the entity 371559. That is the SEC instrument. That's what that is. Business trust assignment, effective date. Oh, look, we have a flyby. You guys might be able to hear it. Okay. Go to the supplemental paperwork. It's application of exclusive right, a name of business trust, and transfer of business trust name. This is August 7th, 2017. Okay, so this was created, you know, while we're approaching. We're actually in the Fed Circuit, I think, before this, 2017. The district court. Look, this is the J.P. Morgan Chase National Bank Association. So this guy's operating as a J.P. Morgan Chase National Bank associate, and signs it Christopher Eric Fite, printing his name as this, which is a state instrument, 23148. So this is where he converts a federal securities instrument, okay, in he registers it under a federal security, okay, 371559. Okay, and these numbers, you know, they like to they flip the, you know, different hats, hat number this, hat number that. But this jurisdiction, 231486, is a state jurisdiction. And then they have a second witness of Ralph J. Bradley, also as a J.P. Morgan Chase National Associate. So this is J.P. Morgan Chase people, at least operating, they're saying they are, operating, flipping around a federal securities interest and signing as fictions or registrations in the state of Ohio, okay, with new numbers of Christopher Eric Fite. And here's, you got Christopher Eric Fite. This is where he is the holder, okay. Notice it's Christopher Eric Fite, not, this is the avenue here. I mean, this is what they do. They change res ident. So they're, and this is a fictitious name registration. So this is them registering Christopher Eric Fite. I'm not sure if it's the 2314860 state one, right? So you see how they commingle the names. They twist the names. They abbreviate the names. They change the capitalization, the mixed capitalization. They pollute the gloss. But in this case, you see that the Federal Reserve Bank and Fite Company is a fictitious name registration, with the holder of the instrument being the Board of Governors of the Federal Reserve System for 180 East Broad Street. Okay, so that this is showing the association of the Federal Reserve Board, the Board of Governors of the Federal Reserve System, okay, registering this Federal Reserve Bank and Fite Company holdings. And this is the general nature of business: to expropriate private property for public use in the erection of the Federal Reserve Bank and Fite Company, holding with a lien land registration LR 1248 on lawful conveyance, who sells collateral debt obligations to J.P. Morgan Chase National Association, registered, that's 2118141. That's a state issued instrument, at a discount via international wire transfer for liability insurance against the public debt, i.e. Federal Reserve notes, and to exercise fractional reserve banking. This is important. To exercise fractional reserve banking in the repayment obligations to the United States, okay? Well, that ain't our United States. That's their corporate, bar union corporate fiction overlay of the United States. Mind you, the significance here is that they are recording the use of fictitious names and Federal Bank and Fite Company for the purposes of the exercise of fractional reserve banking. Okay, so they're going to issue reserve notes. So this is what they're doing here. This is what they're saying they're going to do with this instrument at 180, see, 180 East Broad Street, who is the holder of the fictional use of this instrument in the state of Ohio. See how that works, folks? So they're setting up how they're going to have a front of a federal SEC, with the backdoor holders being the Board of Federal Governors of Federal Reserve System at 180 East Broad Street. So that's what they've done here, okay? We're going to go through this. Again, all about fractional reserve, signed by, look here, Board of Governors. The Fed Fite Board and the Federal Reserve Bank and Fite and Company Holdings, signed by a registrant or authorized representative. Okay, an authorized representative is an individual, then they must sign in the signature box and print their name. The individuals are the Board of Governors of the Federal Reserve System. Okay, remembering under patent law, an individual is a law firm, folks. Okay, you got to remember this twisting of the law. Okay, but I'm showing you how they change hats. Okay, let's go back to my letter here. We've got, there's G, okay, written. Wherefore the flipping, obfuscation, commingling, let's see, emphasizing, yes. D and F. We talked about those. Okay. Wherefore all the flipping, obfuscation, commingling, etc. of entities, instruments at all other than the 1099 proffered to the IRS via H&R Block by said agents, entities, etc. of the Fed, J.P. Morgan Chase et al. Are upon the public record in various federal, state, and court documents in of the District of Columbia, State of Ohio, the Commonwealth of Puerto Rico, etc. Wherefore the reorganization and remonetization of the Fed was fraudulently effected by the Fed fight fiction, along with ins legis federal and state agents of the State of Ohio, using a negotiable instrument that I am the lawful holder of as relator, settler, and trustor, having acquired a return receipt from the office of the Chief Counsel for the IRS in 10/2015. See Exhibit G, abbreviated as 5 pages, attached as if fully rewritten herein, for a default judgment in bank upon the United States Treasury in case 18-5369 with the District Court of Appeals, District of Columbia, as initiated 12/26/2018. Wherefore I can reproduce the receipt of this document under relator's wet ink, seal, and signature from the Chief Counsel for the IRS as representative of the United States Treasury if need be. Okay, remember, I did a video on this, folks, that I got this nifty little letter back from the IRS Office of Chief Counsel. Let's get past these. These are the state property, state records. Okay. You see this little instrument? R. Exton Lotus Adjustment. See how he took what I created as an all capital instrument and they sent it in printed format. This is reduced. Internal Revenue Service. I could flip it. I don't really care that much too. You guys can see that it, if I rotate it, it's clearly an envelope made out to R. Exton Lotus Justice. Folks, this is not a person in a physical sense, my flesh and blood. This is an instrument of negotiation. It's a negotiable instrument name is what R. Exton Lotus Justice is, okay? And the significance of this is that within this envelope made out to R. Exton Lotus Justice was the envelope that I sent to the United States Treasury, care of Mr. Munchen. Okay, so I got back a letter that was specifically sent, addressed to the Secretary of the Treasury, and got it back from the Chief Counsel for the IRS as stamped, received. And you'll see the back of the envelope is stamped, received, the original. See, August 12, 2019. Then internally, this is the cover letter of that in-bank. And then the very last page of that in-bank is stamped on the back, August 28th, 11/32. Now, most people don't understand the significance of getting a notice of default, which is what this is. This is really important. This is why I put the cover letter in here. This is a notice of in-bank default, notice of the clerk to issue a bill of certiorari pro confesso. Okay, that means they were supposed to just prima facie issue a bill of equity concerning this case, which they couldn't do because that would be exposing the fraud. So instead, what happened is that the IRS, as counsel for the Treasury, sent me a paid or a stamped return receipt of the default. This is a return receipt of default, folks. This is a lawful document of a notice of a default upon the Treasury and the bank of the District Court of Appeals for the District of Columbia. That is the significance of this instrument. That's why it don't matter what they do with the stolen less pens. I, by law, am the settler of the lien, and they may not transact it however they think they have the right to. Okay, but then they've been stealing our instruments. You know, what we're basically exposing is they've been stealing our instruments. That's all this courts are doing, is they're a private jurisdictional private bar party where they bring you and lure you to cure instruments with your signature that you don't even know the value of them, and you're too stupid and learned in the law, and so you're a ward, and so they take your instruments you cured and they go live off 99.9% of it like kings and the high on the hog and do all this crap and make wars against babies all over the world, and then they siphon your estate wealth to you like you're some petty little vassal and you're not owed anything. And that's what the whole courts are. That's what all of them are. And then they take those instruments and they actually wrap them in treasury bonds. And now you know why the stock market's crashing. It gets better, folks, because this isn't going to get any better. This is how things are. This is the law that's been proven. Okay, so let's see if we're still even on live. Hey, we're still on live. Awesome. Okay, let's go back to this part of the letter of rogatory. Okay. Okay. Back up here where I'm the only one. Okay. Oh, here's where I throw it into DOD. Okay, so wherefore by the law and law statute, the agents of the State of Ohio SEC Division are not the proper jurors for the matter, as the Christopher Eric Fight LLC used United States Securities and Exchange Commission Form D, Notice of Exempt Offering of Securities, citing OMB number 32350076, see Exhibit H, 5 pages, where the DOD has jurisdiction over pursuant to CFR 2200.800 as subject to 17 CFR 230.500 A and B. As such, this is a matter of national security at this time, as it concerns various jurisdictions, agents, and agencies of state operated in predicated acts of RICO fraud and potential acts of treason upon instruments of the Susticate Trust within the DOJ jurisdiction. Okay, that's page, what page? I'm on page 4 there. I'm going to go now to the form and go and review for you why Form D is so important. Okay. Okay, so this is Form D. In this case, this guy, again, the OMB approval, OMB number 3250076, June 30th, 2012. That's actually around the time when I was already in the municipal courts here in my particular case. So this person used Form D, and this is where they create this 371559 Christopher Eric Fight LLC with a securities and exchange form in the District of Columbia, okay, in Washington, D.C., Form D. And you notice here, again, you got the address in Puerto Rico, okay, and but you also have this address here, 190 Vermont Avenue, okay, and that's in the District of Columbia. Pay attention to the capitalization here, because this gets interesting. He's the executive officer responsible for investing of unlimited trailing stop loss in the national product of Federal Reserve notes for the Federal Reserve Bank and Fife and holding companies and its trustees, J.P. Morgan Chase Bank National Association. So he's even saying here, J.P. Morgan Chase is a trustee, is the trustor of this instrument he's running around. He's doing investment banking, okay. He's doing revenues of over, look here, over 100 million. Okay, which is the highest one he could have, it looks like, of revenue. Okay, notice this is revenue. And then there's one more. Debt, option warrant, or other rights to acquire another security. Yeah, by stealing them. These are routing, look, these even tell you the routing transits they're going to use. And these coincide with things that did flip through the state of Ohio. They actually have checks being flipped in this conveyance and the re-upping of the Fed with, I'm going to tell you, stolen instruments. Regardless, you'll see that these, oh, here, they're going, proceeds as floating loans cleared on certified notes drawn on Federal Reserve Bank and New York as IOUs and negotiable instruments for liable insurance protections in commercial and public finance transactions, okay? So this is, again, I'm going to probably put this out. Here's the significance. See this right here? Signature, issuer, mixed uppercase, lowercase. Then the signatures in all capital. Then the name of the signer is another instrument. I don't even know who this guy is. This 4060242. I should look that. Maybe I did find that. Maybe that's his Puerto Rico issuance. I'll go look there. So this is, you know, this was the Form D that he used to create, okay, himself or itself. Let's go back to page 4. And keep reading on here, okay? Because this even just gets better, folks, okay? I promise you it gets better. Additionally, this very same entity registered in the Puerto Rico Secretary of State as Christopher Eric Fight LLC, care of Expert Corporate Solutions, at 988 Luis Muniz Riviera Avenue, San Juan, Puerto Rico 00975. See Exhibit I, which we'll go look at, as adjoined to the fraudulent filings of the Secretary of State documents concerning said fight remonetization, is currently listed as a lease counterparty in the bankruptcy of the Commonwealth of Puerto Rico, case 17-3283. See Exhibit J, per case 17-3283, docket entry 963. See, I pull these entries off, but I cite mine, folks. You can go actually look at exactly these pages. This guy just pulls them, and you only know when I go into the lengthy thing I'm going to do. You don't even know where they're from except for the printout of a case number. You don't even necessarily know what case number it's in, except for maybe reading what's within the case. So this guy, these people are pulling stuff from all over these cases to give a presentment of liquidity and legitimacy, and it's all fraudulent cases that were all shut down for default with prejudice, some of them. So, but they go and create these cases to create false instruments that imply liquidity and assets, and then move them, in the case with Ohio, to fraudulently re-up the Fed, fraudulently with stolen instruments, and fraudulently with an instrument that's barred from doing what it's doing, which I'll show you in a minute. Wherefore this bankruptcy case would be a means to hide by seizure under said bankruptcy said agents and agencies et al. enjoined in the acts which reorganize and remonetize the Fed. Okay, so let's go look at these I think J and I. Okay, there's H. Okay, here's I. Okay, so here's the Registry of Entities for, I believe this is, yeah, Government of Puerto Rico. Now here's the funny thing about this. There is no secretary. Puerto Rico is not a state, folks. Okay, so there really is no Secretary of State. If you go in here, and I can prove that basically all they're doing in this filing is just paying a fee to get an issuance of a certificate of good standing. But if you go and look at half the people that I went through, anyone that I registered, none of them have tax returns filed, and these are international negotiable instrument flippers that are operating through the SEC. So the important significance of this is that, too, the status of this instrument, where it was originally filed from, the Puerto Rico, remember in the SEC filings, it was canceled. Okay, it was canceled just the end of this year. Imagine that. It wasn't created until 2016, though he says he's registering this instrument with Puerto Rico, and yet in the DC instrument he cites a Puerto Rico address, though he's not registered in Puerto Rico at the time. And again, we see this address here, 109 Vermont Avenue, and the designated office address as Expert Corporate Solutions. Yeah, they're expert at stealing instruments and remonetizing them for their masters, is what they're doing. So, and again, to engage, this is a purpose, to engage in the acts of international free trade and commerce, and to draw from its international monetary fund, through payables numbers 33811375337 receivables in designation to verify credit of foreign exchange for non-commercial lawful money creation and self-insurance purposes. Okay, so this again is them using it, registering the instrument Christopher Eric Fight LLC, registered in the District of Columbia under this address, under a Puerto Rico address, so it wasn't registered here at the time, in Puerto Rico. Okay, and it's already been canceled. And the reason why it's been canceled is they didn't pay anything. They just created it and they sat on it. There's a case involved in it that they commingle in Ohio for the purposes of fraud, as far as I can tell. And then this has just recently been canceled. So the instrument registered in Puerto Rico has been canceled for failure to comply with the mandates of registration. Okay, by the Secretary of State of Puerto Rico, which doesn't exist because it's not a state. Okay, if you guys can wrap your head around all this lies. Okay. So let's going to go back in here where we're talking about the instrument. Okay, here we go. Fully monetize lesser party, J. Let's go look at J. I forgot about that. Here's where... turn it around. Let's see, this I might flip. View. Rotate. Crap. Let me see if I can find a rotate. If not, the point is this. And you guys will be able to look at this. See this right here? Care of Expert Corporate LLC. Let me see if I can get this to flip. Rotate. Right. Okay, here we go. Columbus Networks of Puerto Rico. Care of Expert Corporations LLC. Same address. This right here, folks, case 1703283, docket entry. This is the bankruptcy of Puerto Rico that Trump has tried to facilitate with screaming and crying about the government of Puerto Rico, when the facts of the matter is that the FBI run Puerto Rico. So in any case, anything that comes out of Trump's mouth, either he's stupid and doesn't know how Puerto Rico is organized, which is totally possible, because he's a ward of Barr and hasn't been told, because then he might know what the hell they're doing all the time. So even regardless, either he's ignorant of how it's organized and run, or he's willfully stupid, which I'm going to say willfully stupid or acting that way, because Mr. Trump has purchased over 27 properties in an area called La Perla and held them there since as early as 2009. Thus, my knowing who Trump was before he ran for president, and knowing that he is a key property holder in that territory, which is an international heritage zone declared by the United Nations and all, that they hold holy and historical places. La Perla is the old San Juan Castle land where the slaves, so basically they're the landed slaves of the old castle of San Juan that have lived there for 500 years. It's their allodial land. Trump was trying to build a casino there. Okay, literally, he wanted to rip out all of the landed old slaves whose family built old San Juan Castle over the course of 500. They've lived there hundreds of years. It's their land. They acquired it by being left there, by the occupiers. And he bought like 27 properties. There are only like 250 properties in this little. It's called the Pearl, La Perla, the Pearl. It's in the little cul-de-sac of the outward wall of Old San Juan Castle. It's prime real estate. Well, Trump wanted to put a casino there, so he bought 27 properties. Whether he bought those properties lawfully, I do not know, because the FBI went into La Perla in the mid-2009 and basically disappeared their city council and cut off all the electricity and the water and things like that from the San Juan, the old San Juan. So there's La Perla and old San Juan. Then there's San Juan, the new corporate San Juan on the island of the Commonwealth of Puerto Rico. La Perla is an international zone sitting as the very first port of old San Juan, which is itself an international zone, sitting in the cul-de-sac surrounded by the corporate old San Juan. So Trump was trying to make a casino, a Trump casino, in the international heritage zone of the landed slaves that built the port of San Juan, the castle. Okay, he wasn't very well liked. He's still not very well liked. And the FBI basically conspired to get rid of the city council, the elected city council of this international independent city called the Pearl. And they've not been seen since. And I came into an understanding what the term La Perla when I went to Puerto Rico and saw the real treasury sitting in Old San Juan streets, okay, on Old San Juan, the port of San Juan, not the port of Rico of the corporate San Juan, okay, and saw a phrase called La Perla no se vende. The pearl is not for sale. That was for Trump, folks. So I have a hard time believing that Trump doesn't know that Puerto Rico is run by the FBI, especially since I have recently been sent paperwork that shows that Trump was a CI for the FBI and all his ramblings about trying to create casinos in his own name. So in that regard, let's hope that Trump's clean, because at this point in time, being if he's related to anything related to Puerto Rico, in Rico, Rico in the port of Rico of San Juan, now Puerto Rico courts and state are enjoined in my son's case, and in the criminal seizing and re-upping and remonetization of the Fed. So that's where Trump and his, the city of, mind you, if you research the bankruptcy of Puerto Rico, did you all know that they're trying to seize the Commonwealth of Puerto Rico? Did you know that they're trying to use the mismanagement of the attorneys of the corporate charter of Puerto Rico, who are under the direct thumb of the FBI? They're trying to use their mismanagement and use those corporations to bring them into bankruptcy, to steal the land of the people. Okay, so now you just have Trump getting his little, he's going to get his la pirla, whether it be it through a bankruptcy of Puerto Rico that's fraudulently enjoined with all these people who clearly are criminally running around with JP Morgan Chase and traders and people like that are remonetizing the Fed criminally. And this is how, this is the best part of of this whole letter, folks, coming up here, okay? This is just the icing on the cake, besides the fact that it's already enjoined in this. Page 5. Got to flip it back. Rotate. Back. There we go. Okay. So, go back to my letter here, where I'm noticing them of all this stuff. Okay. So, wherefore, this bankruptcy case would be means blah blah hiding. Again, I reiterate, this is a matter of national security at this time, and I did say this a couple times. Again, I am the here I'm going to go into here. I've read all this. Again, I am the sole lawful relator, settler, and trustor said claims, the creator of the les pens used in said fraud, the holder controller of the default judgment in bank upon the United States Treasury in case 18-5369 DC appeals, and the receipt holder is said default as received from the Office of the Chief Counsel for the IRS 10/2019. As such, consider this claim upon said predicated acts of RICO fraud and potential acts of treason, which should be treated by your federal agency as a quasi-whistleblower notification of said fraudulent and criminal acts against my personal property as negotiable instruments and the various treasuries, be they de jure de facto under bankruptcy receivership and the American people, citing Barron v. Baltimore and Martin v. Hunter, which lays within the jurisdiction of the DOD under CFR 17 CFR subsection 200.800, subject to 17 CFR section 230.500 A and B, prima facie, pursuant to the various instruments of negotiation, state and court documents as provided herein. Wherefore, pursuant to the administrative orders number SB-SCD 13-12, see Exhibit K, final decision and order, and its associated proposed default decision and cease order issued by the government of the District of Columbia, Christopher Eric Fite, in parentheses, as chairman of the Federal Reserve Bank and Fite Holdings, located at 1090 Vermont Avenue Northwest, and in Ohio located at 3404 Charlene Avenue Southwest Canton, Ohio, and American Investment Group, have already been ordered to cease and desist from offering or selling any securities related to a Form D notice filing received from American Investment Group dated June 11, 2012. Wherefore, in this claim, prima facie, said persons have merely operated under by Christopher Eric Fite all located at the same resident address, seeking to obfuscate such associations with American Investment Group. As such, it is incumbent upon you and your agency to assist me in completing whatever steps need taken by me to bring this fraud to the law and the proper jurisdiction under the DOD to correct this fraud and criminal acts in violation of the federal regulations and statutes at all, which all ins legis agents enjoined therein thereof are bound. I eagerly await your reply. Now, that's under seal by me. That's my signature and seal. It's my seal right here on the left. Now, the left seal controls the instrument. I don't do everything on seal. This is on. Okay. The last instrument, which is very important, is the DC case, which I told you was provided to me by the DC agent. He was very happy to send this to me. This is an administrative order from 2012 that says, January 16th, 2013. Okay, this is well before they brought this instrument to Ohio and used it as an instrument of commerce to issue notes. Okay, that on this order, January 16th, that as a default decision be entered against the respondents on charge of violating DC Official Code 31, and it is that the respondents and their employees, agents, assignees, successors, and associated entities shall cease and desist from offering, selling any security in the district related to the subject Form D notice filing June 11th, 2012, and making any statements as representatives that American Investment Group is organized in the district. That they were actually made to pay a $40,000 fine if you actually read the paper report, because they published this in their registry. And that's how I found this. Okay, so this was sent to, look here, Department of Insurance Securities. Okay, Christopher Eric Fite at the 190 Vermont, at his Canton address, at the Canton address of American Investment, at the Federal Reserve Bank in Fite in Canton, and at his Washington, D.C. address. Mind you, these are the people right here, okay, in these state documents, okay? These are state instruments dated past 2013, okay, that in D.C. were deemed not able to be in the proper form to sell securities. And here you have Christopher Eric Fite, okay, right? Remember this? JP Morgan Chase, dealing with JP Morgan Chase, right? JP Morgan Chase associate with Christopher Eric Fite. And then the next one, Federal Fite Bank and Holdings. And this was filed on, what's the filing date on this? It's at the top on all these. This was filed in 2019. So this instrument, the same instrument, was in DC, found in default as not organized properly. And here it is, working with the Board of Governors of the Federal Reserve Board in the state of Ohio, in Columbus, Ohio, to monetize a stolen instrument and to, again, issue Federal Reserve notes and to exercise fractional reserve banking. Well, the order basically said you're not to do that. You can't use Form D. And yet they reference back to the instrument in the organization, okay, to Form D right here. Here you go, right here. This instrument right here, this Christopher Eric Fite right here, folks, right in the middle of the page, that is the Form D instrument. That's the Form D instrument they were told they couldn't use in 2012. So you have a guy who just reorganized the Fed, and like I said, I'm annotating it. I'm doing a negotiable instrument audit of their activities. And I already have 11 pages of annotated, and each one is a date with a particular negotiable instrument that they defrauded. Like, I mean, it's like the dude's just flipping hats over here and there. And they actually say in the paperwork where they do a civil forfeiture on the Republic State of Ohio that they own the state of Ohio. So now you have JP Morgan Chase thinking it owns the state of Ohio because it seized my instrument, because I actually own the state of Ohio. See how that works? I seized the Treasury, I seized the state of Ohio, and the backdoor attorneys slid my instrument over and commoditized it as a 1099. And that's what they do with everything you do. And when you read what they did in Ohio, they came back and they paid Stark County like $2 million. There's actually paperwork with a Stark County prosecuting attorney's stamp on it and initials of a fraudulent UCC lien on the state of Ohio by JP Morgan Chase, who doesn't show in personam, by a JP Morgan Chase associate. I mean, it's bad. And then turn around and issue a $10 trillion bond. And now you know why, if you're from Ohio and you understand that Ohio is the heart of it all, how suddenly all these CPA agencies are getting all this money, and how you're seeing all these. And I've actually commented on this, you know, that they're using my money all over Ohio. And that's what they're doing. They basically paid Ohio. They rewarded Ohio with $10 trillion in municipal bonds for stealing my son. With my own instrument. With my own private property is what they've done. And so these people are disgusting. Okay, they're disgusting people. And I'm going to show you how there's even more stuff going on. Because it's just, again, what happened with this instrument is, and we'll go over that real quick. See which ones. Nope. I'm trying to find, yep. Okay, so this is the UPS trackers on the instruments that were sent to all of the all of the entities that I discussed that were sent this SEC statement, okay, or this SEC letter of rogatory, where I claim the fraud upon the instruments. And what you will find out, I'll resubmit the form, is because I go in here and save it regularly. All of the forms, mind you, the first people to receive the notice was the state of Ohio SEC. So they received it on Friday. You will notice that, oh, that's this one, wrong one. You will notice that there are 2 or 3 that are still not delivered. That was of this morning. I haven't checked since this afternoon. Let's see if they're all delivered. But the significance is this one, 3012. I can tell you what they are because I have them. 3012 is to the Department of Insurance, Securities, and Banks, Theodore Miles. That's really funny that he hasn't gotten his yet, because he was one of the first I communicated with. Then we have 3050, which is the United States Army Intelligence and Security. Now, mind you, these were mailed. These were mailed, folks, on the 27th. Okay, you see how they block out for delivery since the 2nd. See, available for pickup. They obscure ports. The other one was delivered today. I'll tell you which one, which is what I'm going to tell you caused the problem, because these have been served throughout last week. So the courts know what's going on. The SEC and all these people know what's going on. The people who are buying stock don't know what's going on. Okay. But everybody who's running the game knows what's going on. Chief of Staff 3005. Okay. The one that caused the problem this morning was the one that was just delivered this morning at 7:09 a.m. Okay. And that was delivered to, that's right here, 7:09 a.m. today. A full 7 days, more than 7 days after it was mailed to them. This history is 3005. I'll show you guys. 3005. So it says Joint Chiefs of Staff. The Joint Chiefs of Staff, before the markets open today, got a notice that the SEC is a criminal instrument and has been using to flip instruments through, create fictions that then seize things and monetize over here on the back door. That's why the market crashed today within 2,000 points within 15 minutes. And here's another reason why, and that's because I'm going to show you this. And this, I'm going to show you this, and then this will just probably make you as sick about as you can be. This is where you would go, you know, like I said, it says Department of State, Puerto Rico. You know what's a Department of State? Because there is no state, Puerto Rico. It's a Commonwealth. And the Department of State, remember, under the Habana Acts, has no powers. That was all slid into the bar union. So the bar union, bar people, the attorney general controls all things Puerto Rico. So when you hear Trump piss and moan about Puerto Rico and blame these people or that, he is either lying to your face as an idiot of how the world works under the United States government and the administration of Puerto Rico as a commonwealth, or he thinks you're stupid and you don't realize and don't know that the Department of State and or AKA King Poobah Barr in his 5th private jurisdiction and the FBI run Puerto Rico. So anything that's related to conspiracy of Puerto Rico and frauds in Puerto Rico is totally under federal jurisdictional mandate. And there's no need to bankrupt it unless you're just trying to steal the island, folks, like they try to steal everything else. But here's the significance of why I'm bringing this up. Under the Puerto Rico registration, we talked about this. You see this address, 109 Vermont Avenue, Suite 910. Well, let's just go search that. Let's see what we got here. Here's his Christopher Eric Fipe. There's a backdoor SEC filing page. If you go to SEC, you won't always get an honest answer when you search. I'll show you that. I'll show you that shortly. But let's go put this address right here, 190. Let's put in a start page. Okay, look, check it out. This is, you know, you just tab down a little bit. Look at this. The same address is used for junk removal in Washington, D.C., as in junk bonds, you know, guys, folks. Funny. But the one that sticks out the most is this legal notice terms of use for Davis Law Firm. Check this out. This is Davis Law Firm. So that means they're associated with his address now, folks. Look here. Send service process to InCorp Services, 1090 Vermont Avenue. This is a huge law firm, folks. This is a huge law firm in D.C. They do entertainment, trademark, copyright, labor, and employment. Oh, I bet they do a bunch of patents, too. So they even tell you to use this same schmuck, the same address that this schmuck in Puerto Rico that's flipping criminal instruments in Ohio, that's canceled. His registration, send your stuff to him if you got a problem with Davis Law. How do you like that? Gets even better. And this is actually the disclosure of 2 firms getting penalties, and this is everything about, look here, 110 Vermont Avenue in the district and in Canton, Ohio. This is the original. This is how they got zinged in October 10, 2012, doing the same kind of stuff. This is what do I have this one? Savoy Partners. I think that this is related. Yeah, if you go into some of the cases that are involved in Puerto Rico and or some of the other deeper addresses registered through these instruments, you get Savoy Partners. Oh, the Savoy Partners is one of the litigants in the DC case, or sorry, the District Court of Puerto Rico case that he brings paperwork to the state of Ohio in. So then you have Savoy Partners, and they are they do securities work, if I remember properly. And then there is another court. Here's where. So this is where this gets interesting when you're learning about the SEC. And we're talking about King Poobah Bar. Everybody remembers that, well, you can look it up. Here's an article by Politico. I think I already have this out. Yep, right here. I already pulled it up. This is the article by Politico. It says DOJ taps U.S. attorney to coordinate Ukraine inquiries. Now, this is important because this isn't just any Ukraine. What he's done is he's telling the world, if you are bringing complaints or evidence against Joe Biden or anything related to the Ukraine incident to a non-governmental source, meaning if we don't have it and you're just a private citizen, you can bring us all your evidence to this guy. Okay, remembering that everything they do is about piracy capture. Remember that. Everything they do is about sticking things in little bags and carrying it off. Little securities holding. Think of the security as a little bag of shit they put stuff in and tied it up and cinched it, and they're carrying it around like it's theirs, and it's really not theirs, but they're still, well, look at all these securities I own, and none of them are theirs. Okay, so remembering that everything they do is an act of piracy. Okay, wait till you see this stuff. So I go in, and if I, here's the whole article about it. Meet this attorney. And this nice guy. Look how upstanding he is. He's a nice guy, right? J.P. Donahue is the United States Attorney for the Eastern District of New York. As U.S. Attorney, and this is Richard P. Remember that. Okay, well, here, if I actually do a search for a Richard Donahue as a United States Attorney for Eastern District of New York, I get this really weird thing. I get this, right? But look here, I get the Bloomberg. I get a Bloomberg profile. What the hell? What the heck is a Bloomberg profile? Again, here's his tap out, right? Look here. He's got a Bloomberg profile, folks. Oh, let's re-hit this. Richard Donahue, the interim U.S. Attorney, United States Attorney's Office for the Eastern District of New York. Imagine that, out of New York, acting. Well, and honestly, folks, before we even go into this, okay, before we go into this, because I'm sorry, I wasn't on display capture, so I'll back on the video. I'll go back to display capture here in a second, and go back over what I just did, because I clearly messed that up. You have to think about, remember that not too long ago, 2,500 attorneys wrote a letter saying that King Poobah Bar needed to recuse himself. It had nothing to do with anything related to Epstein or anything. You know why they wanted him removed? Because they knew that Barr had authorized what they just did with the Fed, okay, and with my stolen instrument. There's no way what happened with JP Morgan Chase, and when I get to the longer thing, you'll see that the United Nations Council 300's names are flipped into those instruments of the 11 pages, showing them enjoined in this activity, okay. They knew that Barr would have had to authorize everything that just happened. There's absolutely no way that Barr doesn't know that JP Morgan Chase just paid off its IRS lien of like $104 billion and is remonetized in the state of Ohio, operating as an entity. Well, now he for sure is, because the Department of Defense just got the complaint about how this criminal instrument was used to do just that, right? With a stolen instrument of mine. So let's go over, let me go back. Sorry, I apologize for not having the display capture. So we'll go back over what's going on here, okay? So again, this is his Puerto Rico registration of this Eric Fight LLC, 190 Vermont Avenue. We can do them in this back door. This is a back door, kind of a private, where you can pay to pull registrations. And I would suggest not just using the SEC, because I'll show you later that the SEC obstructs certain searches. So I put this address in, again, into just a start page, and I get this as a junk removal in Washington, D.C., okay? And the other instrument I get, which I find the fact that this is a junk removal cover, we've moved. Oh, there you go. They're new. And then the other one is a notice of law terms and disclosure from Davis Law Group. And here's where this is. This is the big one. See? InCorp Services. So now we have him operate another instrument operating out of this address, other than just Christopher Eric Fight, called InCorp Services. And if you're trying to serve Davis Law, who are PLLCs, which do entertainment, trademark, copyright, and all these things for patents, if you're trying to serve them of any type of legal notice, you're to serve the same address as the Christopher Eric Fight fiction. Now, mind you, this is a big law firm. Their law firm, that's not their address, folks. Their address is 611 Pennsylvania Avenue. This is a big law firm. A big law firm has the same address to send legal notices to as is registered to a canceled Puerto Rico fiction, Christopher Eric Fight, as with the registration number from District of Columbia that is been told not to offer securities. Okay. This is, again, I don't know that let me make sure I have my, yep, now I got it. Okay. This is the original publication where I did a search on Federal Reserve Bank and Fight Company and found the DC case from October 10th, 2012. This is the report on that, of cease private securities offerings, which is what they've done for JP Morgan Chase. The reason why I bring up Savoy Partners is Savoy Partners LLC, which is located in Puerto Rico. It is associated with Puerto Rico District Court filing that Christopher Eric Fight brings into the state of Ohio to show some type of securitized instrument as a check from JP Morgan Chase. And now I want to talk about how the DOJ has tapped a man named Richard Donahue. Okay, we're going to go back over this. Richard Donahue, operating as, here they tell you, meet the guy. He's actually classified as the interim United States Attorney for the Eastern District of New York. They don't call him interim here, but in I think in one of these he is classified as an interim. Regardless, if I research this guy on Google and his title, okay, Richard Donahue, U.S. Attorney. Look, that's all I'm doing here, folks. Just research this title. Okay, it's a seat. Remember, these are Sethians. The seat. He's not a man. He's a man in a seat, but he just wants to operate as just the seat and act like the man in the seat is immune. So look, he's got a Bloomberg number. Okay, why does the United States Attorney's office have a Bloomberg number? Oops, it's right here. So what we got here? Hold on. What do we got here? I already have them pulled up. I didn't want to double pull them. Oh, that's the Weave Move. Here's the Bloomberg number. So here is the Bloomberg number for Richard Donahue, the interim United States Attorney. He's got a Bloomberg number. Look here, 1334121D US. What the heck is that? What the heck is that? What does Bloomberg do? That? Look here. He's got a history, present, He's a judge advocate. They've got his whole, look, his whole persona has a Bloomberg instrument number. Look at that. And guess what? It gets even better. This guy actually has a Bloomberg value, you know. So apparently if you're an attorney sitting in a seat of government, you have a Bloomberg stock quote value. Are you starting to understand what they're doing here, folks? They're using the SEC as to create patented instruments as hats, okay, where they then go and do criminal activity. And in this case, what they're doing in that they have a Bloomberg number. See this number 1334121. Let's copy that. Let's go into the SEC and see if we get anything when we put that number in there. Okay, just that should do it. We can do a company name. I think we can do more options. Hold on. Let's do more
U.S.
options.
Securities and Exchange Commission.
File number. Let's do the file number.
To search by file number.
Because I've done this before.
To search by file number,
Should get
company name must be left blank.
It's not even going to let me do
To
it.
search by file number,
Make me type
company
it.
name
Makes me
must
that
be
much.
left blank.
Oh, there we go. Okay, let's see what we get.
State.
This is actual SEC search here. Folks.
Country.
Let's see. No file matching. No matching file number. Now SEC numbers are singular, folks. They don't reissue them. They don't issue 2 or more of them. Okay. So I went and took this number, this 1334121D number that they pull off Bloomberg, and I went to the SEC and got nothing. And yet, if I go to this backdoor group, look here, if I go to a backdoor third-party private corp, not through the Federal Registry, SEC, and do an SEC search, I get an AeroGrow International Inc. out of Colorado that translates to this dude's Bloomberg number as a seat of state. Okay? Are you getting that, folks? Now, if I go back and put, again, here's more of the filers. If I go and put AeroGrow International Inc. in this SEC search, watch this. Look, I get a number 1334121. You see that? See that Bloomberg number 1334121? You see that now SEC number that won't come up with the number, but if you put in the corporation name, okay? So these, and this is in Boulder, Colorado. So they sit here and they hide activity in SEC registered instruments. They hide criminal activity. Let me reiterate this, folks. Okay, what my son's case has proven is that the courts are merely piracy capture forms, where they then take the instruments that you cure with your signature, in which case it's cheaper for the Republic to just go in and pay the ticket, because every time you challenge and then you abandon, that just makes that value more. And in my case, just so you know, I've had my CUSIP number looked up. My CUSIP number is worth $6 trillion plus. My wife's $16 trillion. My son's $500 billion, and he's 7. Okay. My daughter, more than $1 trillion, and she's 12. Okay. That's why they steal our babies. Because your babies, because of their name and their allodial inherent estates owed to them in the realm and the whole world construct, are worth, for some of us, godzillions of dollars. Because we actually are the blood right heirs to all these fictional landed corporations. These attorneys say own them. They don't own them. They're just sitting in trover on top of them. That's why they're called Hermans. They're Hermanites. And they're the kings of the rubble. That's what the word Herman means. King of the rubble. They're the guys that just are occupying the temples they've collapsed through fraud and corruption and racketeering and the stealing of the kings and the murder of the kings and the murder of their babies and the stealing of the queens and the kidnapping of their sons and then raising them in the wrong crown. You get it? Queen Elizabeth, Mary Queen of Scots. That's what they do. They're stealing the king's flesh now, literally, now with an instrument, then going after the king, my son, who's the blood right canistry heir to the land of Croy, which is an independent crown that holds all of Scotland, okay? The Croy Crown is the High Crown of Scotland. Okay, it kept Scotland free. The Croy clan kept Scotland free. So they just took an allodial heir of the Free Crown of Scotland and disappeared him. You know why? Because he's worth $500 billion as an instrument. And who holds the man? Holds the treasury of the instrument. So they're just seizing you so they can go around and eat off your shit while they trafficking you prison and trafficking you there. They're just over there eating off your bank while they're trafficking you as a pauper. Okay? So I've just proven that the United States Treasury, basically the SEC and everything, is just utter crap. It's all lies. And now you know, since my instrument hit, not last Monday, but it hit the Ohio SEC on Friday the 28th, or 7th, whatever it is, Friday the 27th. Okay. Monday, Tuesday, $1,000, 1,000 off, 1,000 off, 1,000 off. Monday comes after the DOD and the head of the department, the dude, the big honcho sitting next to POTUS, is served at 7 a.m. They open the market and it crashes 2,000 points and they shut it down. You know why? Because everything in the SEC and the stock market is fraud and crap. And their activity with our instruments, my instruments, and the activities within my son's case prove them all totally crap. And the whole world knows it's crap now. Because if you look at what they're saying happened today, they have security returns are almost zero. Yeah, because the treasury, their treasury is seized. It's as a fraudulent instrument. It's now going to be looked at. The book's open and we're going to go, hey, how many frauds, how many children did you kidnap? And we're talking about back to 1940. We're going to end up showing the United States government, folks, is going to be proven, not only with agents within it, to have killed its own president in JFK and Bobby Kennedy, because those were the two instruments of the Havana Act, would be controlled, the Havana Act, and they probably weren't going to play the game of the coup, right? And so they had to kill them both. Those instruments, they were murdered because of the coup. World War II and all of the criminal activity of the Zionists and the flipping of people in and out of Germany and all the human trafficking and crimes against humanity that they brought 4 lowly corporals at best to hang for, that was precipitated and done within the Havana Act private jurisdiction by the United States government in conspiracy with international bankers and agents from various other countries, nations, not countries, to conspire to basically, what you're going to say, they harvest. That was their first harvest of humans. And they've been harvesting humans and perfecting the ability to basically kidnap and harvest humans and do whatever they're doing with them under the presumption of them being a court and being the law for a very long time, like thousands of years. The heretics have been in charge of this false temple. And I'm going to talk about that at a later time, but what's happening now in the market, it has nothing to do with the coronavirus. It has nothing to do with the fact that Saudi Arabia is in an oil fight with Russia. Why would our markets care? We're the #1 producers of oil in the world. It should make our market go up if they want to start scarcity and they have an interior conflict, because we can sell more oil at a higher rate. But no, oil's at $27 a barrel, folks. The market's not going to crash because of that. It crashed because the highest, quote, officer as a cabinet post of POTUS was served a notice that J.P. Morgan Chase agents, Fed Fight Company Holdings, Chris Farrick Fight, Stark County prosecutors, Secretary of State agents, DC agents, Council 300, United Nations, all these instruments have their fingers all over a criminal reauthorization of the Fed, where J.P. Morgan Chase claims to own the territorial state Ohio. Now, why isn't that in the news? Okay, so now you have the basics of what's going on. I suggest that you get prepared. I have refrained from making any public declarations or doing any videos concerning this because the information I'm conveying is critical to national security. But I'm telling you so that you all know the coup is screwed. The Fed is seized by a claim of a fraud. Even if they aren't using our 1099 less pendants, which I'm going to tell you they are. Because if you saw the timeline of cases versus the use of instruments, you'd be like, man, you didn't even wait 24 hours. They didn't even wait 24 hours to flip that thing. Regardless, someone better produce a wet instrument les pens that actually, by the way it was told, has already cured on our side of the dock for 14 days. 14 on the bar, 14 on my dock before I handed it to you. And I was like, I bet you guys are dumb enough to. And I put it there as a marker. So they conspired with the mandates to seize that marker, and the next day went and recommoditized it. It's that bad, folks. And we'll find out because, hey, now I'm laying a claim on a whistleblower at the state of Ohio because, I'm sorry, but JP Morgan Chase does not own the state Ohio. It does not own the United States of America. JP Morgan Chase is not the Fed is not private property. And the holdings of the Fed are not private property. My son's flesh is not the private property of JP Morgan Chase. In fact, if that's the case, then apparently I should be putting them as the head litigant in my son's case instead of state of Ohio, because they must be agents for JP Morgan Chase. Imagine that they are. Imagine that all of the bar union guilds are merely privately contracted esquires who have been paid to make it look like they're courts for the very bankers who steal our children and transact them as negotiable commodities and steal our instruments on the backside of their piracy fifth private jurisdiction created by the Habana Acts. So, in a nutshell, it's very likely that the stock market will crash completely because it's just a bunch of fraud. It's a bunch of men making bets on bets on bets, fractionalizing criminal activity on negotiable instruments. It's not legitimate at all. The SEC is now just a big open piracy sea where attorneys are just doing whatever the hell they want. And the DOD clearly is not monitoring it. They probably don't know they're supposed to. They were probably told by the attorneys for the DOD that, oh, we'll take care of that, which means the JAG is already involved, because they would have to have looked at some of these causes of action over the course of years, which means the JAG are the ones rubber stamping or would be of review. So that would mean that the JAG and the Fed Circuit, I mean, you have to understand the implications of their actions, folks. And it's not like their actions are arguable. They're like on the documents, like it's in documented paperwork what they did. It's in courts of record. It's all for the world to see. It's prima facie fraud. There's no way out of it, which is why the markets crashed today. And I don't think that they're going to open up any differently in the near future, because we have a DOD that has its head up its ass and is in itself being, as my friend says, they all take stupid counsel. They all take counsel from criminal attorneys who say, well, because we said so, that they think they can do it. And that's not the law. No matter what they want it to be, that is not the law. And if you actually know the law and you can point to the law versus what they're doing, they're screwed. So just so you know, I have laid a claim against JP Morgan Chase and all the people associated, the Federal Reserve Board, with the crap and the fuckery that has gone over in the state of Ohio last year, where it clearly looks as though they paid the state of Ohio trillions of dollars in bonded interest loan, derivatized loans to kidnap my son. In which case that lends us back to, you aren't immune from crimes, especially of state, against persons non compos mentis, which is infants, insane, infirmed people, when you have a pecuniary interest in the actions you take, and or when the commodity or instrument of the object of the claim is something you lay claim to. So those positive law things right there would prevent any county from hearing any cause of action where they take a child away from a parent and garner Social Security funds. They can't adjudicate it. It's not within their jurisdiction, because they have a pecuniary interest in the outcome as the state. Because, mind you, Martin v. Hunter, the American people are the highest law. the judiciary of the United States, according to Martin v. Hunter, is a direct servant of the American people's lawful will under the full faith and credit. It is against our full faith and credit to traffic babies, folks. So you have a clear problem where what the courts are doing versus what they're allowed to do by law is the exact opposite. No one is allowed to traffic babies, especially courts and trustees of those babies. Okay. And yet they're not trustees. They're just pirates operating as your government who don't even know that they're stuck in the legal fiction and the lawful pigeon corner of being a trustee. Ah! They're fucked, folks. And prepare, because if the DOD doesn't do its job, all chaos is going to reign, for one. And two, then we will have the Department of Defense openly warring against our children and probably doing the same participatory acts that they did in Nazi Germany. And all the other wars that they have effected against people where they traffic children off the nation's lands after they create orphans with their parent murdering machine. So you guys need to start eating the fact that the United States is a criminal enterprise, has a here's the face of it, and yet over here everything that they do as attorneys is this private fifth jurisdiction, which is just a pirate sea of paper where they sit and steal people and traffic people and do all heinous crimes against humanity, and they just get away with it because they're controlling the enforcement of it in the fictions of those courts, which aren't courts at all. They're just capture machines. They're bank capture machines, which you are not held in equity in. You are held as a debtor to in all cases of action. And yet they need your signature to cure the value of their instruments. So that's the fraud in the reverse ledger. So your government, your treasury, if the DOD doesn't step in soon, is going to collapse. And that will cascade to all the treasuries all over the world because they're all tied to our treasury. And also know that the United Nations is now part of a criminal conspiracy to kidnap and traffic my son, because they're named in the state documents that they reorganized the Fed with. The Council 300 is named in that. JP Morgan Chase. I mean, it's the number of instruments that they just pulled in to my son's case is, which again, you're either up for perpetuation of kidnapping or kidnapping. And so you're either dealing with life in prison, and or if it's conspiracy and treason, you're talking death. So a lot of people just got tangentially attached to acts of potential treason and sedition, which carry the death sentence. Because again, and let's go over this one more time, and then I'll go. But I want to leave this because, you know, I just mentioned the definition of treason to a man in the military. He's like, we're not in war. You can't have acts of treason when we're not in war. Okay, hello, McFly. I'm not trying to insult anybody, but if someone actually affects treasonous acts against you, you are by definition being warred upon, whether you know it or not. Wink, wink, wink. Okay, so let's not be stupid. Well, we're not in a declared war. Okay, you're under Lieber Code. You've been under Lieber Code since Reconstruction. One, you're always under war. That's why the War Powers Acts and the titles were allowed to continue and be enacted. But let's talk about the definition of levying of war so everyone understands, and this is in the simplest form it's designed here. Reading from this wonderful book, okay. Annotated Constitution, okay. There's only so many hundreds of copies of this. I've got 2. My mom's a brilliant researcher. That's why she was so good at her fraud investigative jobs. Levying of war concerning Article 3, Judicial Department on page 507, referencing Section 3, treason. This is the definition of levying of war pursuant to SCOTUS, the post-Reconstruction Article 3 fiction of statute, which is not the Supreme Court as named in Article 3. As Article 3 Supreme Court is not a fiction of statute. by the very language of the article. It is not created by the Congress. The Supreme Court is not, as named in Article 3, little s, big C, is not a court created by congressional statute. Ergo, SCOTUS, as we now know it, a post-Reconstruction fiction of statute, is not the Supreme Court of Article 3. It's basic logic and reason, folks. Truly. But, you know, all that fluoride methamphetamines you guys are snorting and taking. Psh. Okay, levying war. Quote, to constitute the specific crime of treason, war must be actually levied against the United States. And that's why the Army dude was like, we're not at war. Okay. Let me skip down a little bit. It is, quote, the levying war against the United States, end quote, for persons to oppose or prevent by force, number, or intimidation a public or general law of the United States with intent to prevent its operation or compel its repeal. Force is necessary to complete the crime, but the quantum of the force is immaterial, meaning it doesn't have to be guns. It could be mandates of orders of courts, manipulation of facts, stealing of instruments, shutting down your ability to lay a claim upon a court. It has to be something that is an instrument of forcibly preventing you from exercising a substantial right or imposing the mandate of the ens legis agents to follow the statutes as written. Okay, so when an ens legis agent, i.e. a judge, does not abide by the statutory mandates of a law and goes against those statutes, it is the levying of war. If he orders you and says, if you don't abide by my order, I will put you in jail for 10 days. That is levying war, folks. Okay, so if the levying war constitutes a crime specific of treason, war must be essentially levied. Okay, so if someone has prevented by force, number, or intimidation a public or general law of the United States with the intent to prevent its operation, you have been warred against. Now, whether you recognize or know of the warring does not mean you're not at war, folks. So, by definition, if anybody in any aspect of the government is affecting crimes in violation of the law, we'd always be at war. Maybe that's why we're under war powers all the time, because the whole system is levying war against the law. The whole fifth jurisdiction created by the Habana Acts is levying war against the Constitution. So for all you guys in the military go, we can't be trivial, we can't be having treason, we're not in a declared war. The Constitution doesn't say declared war, folks. You just have to be at war. The fact that we're still under the Lieber Code means you're at war. The fact that we're under war powers that have to be reauthorized every 3 years means you're still at war. And when anybody acts in concert to prevent the laws of the United States from being levied, i.e. when you try to impeach a president with false claims of crimes, because it also talks about how to prevent an individual from fulfilling his duties in office is also an act of war. Okay? So whenever you try to prevent a POTUS from doing his job, by bringing false acts against them in concert and clear criminal conspiracy against the established law of Congress to bring a false charge of impeachment, that is an act of levying war. Guess what? You're at war, military. You don't have to go, but Congress didn't tell us they were warring against us, so we were not a McFly. This is a McFly moment for the military. You're at war. It doesn't matter whether you recognize it, the law recognizes it as levying war. So, the Fed, J.P. Morgan Chase, the United Nations, Stark County Prosecutor's Stamp Office, a variety of negotiable instrument notary publics, a variety of people in the State Department, I'm sorry, the Secretary of State's office, they would now know. And now all the people that have been noticed in the Securities and Exchange and the IRS know that they've all, JP Morgan Chase, this Christopher Eric fight, and Fed Fight Holdings, and United Nations, and the Federal Reserve Board, they've all affected war against the United States because they conspired to undermine Treasury law. That's called levying war, folks. So JP Morgan Chase is going to be seized. It better be seized. If the SEC and the JP Morgan Chase and the Fed and all things securities are not seized, your DOD is openly warring against the American people and perpetuating a clear prima facie attempt to steal our treasury, which I hold as a settler as an instrument of default. You don't see me running around offering bods to people who kidnapped my son. But see, that's what they do. They're like, good job, seed gatherers for Satan. We're going to come bring $10 trillion in bonds to your state, revitalize you. You're such good baby traffickers. That's what they've done. So prepare for shit to hit the fan, one way or the other, because if it doesn't hit the fan financially, because they're getting to the point where they can't cover it up anymore. I'm telling you, they're not going to be able to cover it up. If things don't start to, and screw this, in time, just wait. Drip, no. We have prima facie frauds on our treasury and stolen instruments and paying states for kidnapping babies with my intellectual property and the works that I've done in exposing the crimes of state. So all they did was try to just seize my little bag of securities. Well, they don't get to. I'm an allodial heir to those estates. I'm an allodial heir to those estates before they were estates through the papacy, organized under the monarchies of Europe after the Habsburg Empire. I'm way back allodial, folks. I go way back. So I know my blood right. I know my bloodline worth. And they are not going to be allowed to do what they're doing anymore, because they're a bunch of criminals and they're a bunch of heretical, apostatic pedophiles and baby traffickers, and they all need tried and hung for their crimes in whatever means, by hemp rope or by millstone that suits their crime. And it's coming down, and I'm going to make it happen. And in ending this, I'll tell you, anybody who wants to execute a warrant that's lawfully issued and go seize my son and daughter's vessels of their flesh as registered as the land patent birth certificate, you need only lay those warrants that are issued currently on the books in the bankruptcy court, and take those warrants to a county. That's the way Lincoln started his United States Army. Anybody who knows the facts of the case can walk those facts of the case to any court of law. It's like I tell people, what are they going to do if I go arrest a judge? Or they're going to do arrest me for arresting a judge. What would my defense be? Oh wait, here's the proof of his treason. What are they going to do, folks? See, that's where you're at when you have facts on the record that prove prima facie treason. You can actually walk those facts and those warrants. You can actually go and walk the law with them. But most people don't know how to do that. But how do you think the United States Army was created from the militias by Lincoln? He issued warrants. And they took those warrants to the counties and registered a fealty. So, there's the laws out there. It's just a matter of time before all this comes crashing down. And unfortunately, because the manner that they're doing it and unwilling to actually abide by the law, they've walked themselves into a corner where they're actually undoing the law that they've created. They're eating their own system. They're crashing their own works. And that's unfortunate, because a lot of it's good, and and again, corporate platforms will still run on RIM. Humans, people, babies, flesh and blood instruments, and of organic nature are not going to be treated as things in commerce and flipped around as things. We will be curing everyone's birth certificate to the Social Security number directly. We will bypass the criminal conspiracy, which is the coup between the two at the top, where they're running all their criminality as an interpleader on the ledger, trying to hide who they are interpleading for, which is the Pope, the Queen, and all the criminal racketeering of the elite of the world. okay, who think they own us all, right? Because they own my godly flesh. Yeah, not. So shit's hitting the fan. That's what you saw today. And the military and POTUS are going to have to step up and constitute militias and bring forth a proper provost and do what needs to be done, because we're getting to the point where the security and safety of the American people are becoming a problem. Again, I'll put something in the mail and the post will delay it 7 days. They're actually insider trading with these two folks. The fact that the people, the powers that be, knew after Ohio SEC was noticed on the 27th what was going down, and were able to sell and cause the drops in the market, 1,000, just enough to not probably be noticed for whatever activity they were doing. It wasn't enough to raise SEC bells and whistles. But that's insider trading. That's using what's going on in the courts to insider trade commodities. And again, I just showed you how the seats of government have Bilderberg numbers on them that correspond to corporations. I mean, you're basically talking, and now you know why he had to get in the presidential race, because, between the Fed leaving the New York, state of New York, and now being re-upped as a municipality in the District of Columbia, municipal charter, they lost the Fed, and he's losing his Bloomberg betting platform, which has betting instruments for seats of state. I'm sorry, but that should be a crime to do that if that's really what they're doing. But I'm going to tell you, it looks to be what they're doing. They're valuing the surety of the instrument of a seat of state held by an attorney, which tells you that they are not legitimate and they have to suretize whatever seat they create. But they're making you pay for their frauds on yourself. So it's very convoluted. But just so you know, all the crap about the coronavirus, that may be illegitimate. From what I understand, from backdoor people that I know that have direct communications with people that are related to the people that run China now, it was a planned culling of their own people. And they're such sociopaths over there. They are actually talking about it openly to tertiary family members. So that's the Rothschilds culling China. Thus. The revenge upon China, of Godzilla, because they're getting hammered because they need to kill as many people on bond as possible, folks, and that's what they're doing. It's hard to explain how it all works because you really have to be able to wrap your head around negotiable instrument laws. But what they're doing is grossly criminal. Like, it's grossly criminal, and there need be no juries for most of these acts, because the paperwork literally proves the fraud and proves the criminality. And we need no juries. We just need people who want to follow the law that's been well established in the laws of equity and negotiable instruments and UCC to follow it. And they're not doing that. They're presenting themselves as that, and then literally just robbing America blind and kidnapping children to the tune of, well, let's put it this way. I won't get the math wrong. There's like 3.7 billion people, I think, in the United States. In the state of Ohio alone, when I looked at the statistics of how many people they were taking, it was about 1%, okay, of any one county population, okay. That's a year in the state of Ohio. That's what they were basically. So they don't want to be over 1%, because that might look, obvious. But in a county with 45,000 people, of which like 3,000 of them have the same bloodline name, you could take all of them from one family, which is 500 kids and 50,000 people, right? You could take 500 kids out of the same bloodline, and it would look amorphous, but not to that family. And that's a lot of what they do. They particularly target bloodlines of people because those particular children have allodial claims to land all over the world as the original bloodline heirs of the land that have been usurped by all this criminal racketeering of the esquires and the monarchs and the fake pope and the declaration of the Edict of the Worms and all the false popes of the Spanish Medicis, who basically used the papacy to steal land criminally by their papal edicts. I am the king, right? And the Reformation. The Reformation was just basically a banking coup, folks, of the Medici family trying to steal all the allodial lands of that had already been established well as free, and such as Scotland and stuff like that. So that's all these are. You think that they're churches, and they're not. They're banks. You think they're courts, and they're just banks. You think these are just banks. These are people just stealing money from us and stealing our wealth. And they attack children. So, but even still, 1% of 3.7 billion is 3.7 million, you know, a year of children. Okay, move your decimal place. 3.7. I'm going to do it. I'm pretty sure it's 3.7 million. So it's a potentiality that they are privately or probating physical children to the tune of, just in this country alone, if we go with 1% of the population, which is what the average, some of them are higher, some of them are like 3%. They're transacting and stealing, kidnapping almost 4 million children a year off our land alone. And ours is heavily looked at. They have to pretend to do it here. Imagine what the military ops and the Habana Act waters are doing with children in third world countries. How many children are the military assisting to harvest off of our world? Because they're harvesting people. They're not. What do you do with these kids, folks? What are they doing with these kids? And if you understood who we were as a bloodline and who we are as people in this country, you would understand why they steal our children. Because these are divine blood right children. These are children they're special. Okay, they have blood right into them that goes back hundreds of thousands of years. They're like the bloodlines of the gods. They're the fallen children. The children of this planet are divine in their nature, and they are eating our blood because of its magical, spiritual, divine properties. They're using our blood for things. They're eating our blood. They're using our children. If you understood what is going on, you would probably vomit if it was flooded into your brain at one time. In fact, I know you would. Okay. My son's case just took everybody's Social Security and birth certificate, and with what they did in Ohio and the Fed, they just moved everything into military jurisdiction. Everything related to SEC, stock market, patents of birth certificate, or Social Security number are in the Department of Defense jurisdiction at this time. Whether the Department of Defense understands that, I guess they better seek some better counsel. Because King Poobah Bar, if you go to King Poobah Bar and you seek counsel from one of his dudes, he's just going to make that 8-star general the ward of his award. See, that's how it works. So stop asking esquires and maybe start talking to the people who understand negotiable instrument law and actually understand the real law, and who are learned in the law, not in the fuckery of what an attorney says he can do in his little private union practices of nothingness and fictions. So I'm going to leave you guys with that. I will do an extended video concerning the multiple instruments, which, like I said, I have 11 pages discussing at least 5 instruments a page showing the history of this criminal flipping of the Fed. And I have pulled all of the paperwork permanently off the internet and off the Secretary of State's office website before I even brought this to anybody's attention, because we all know how that shit disappears. So that's preserved. Again, I hold a default on the Treasury, and there's no esquire that is going to settle shit for me and my son and the crimes that these criminals are affecting against the American people. Besides the fact I've proven that they don't speak for us and that they are not representing our faith. I did prove that in my son's case. In the recent habeas, I did prove that. There's an example of a oath for the 33rd degree of the Masons in Ohio that show them oathing to Islam. So the Masons, the Masonic order, is not oathing to Christianity, folks. It's oathing to the Persian Median Empire. You know, many shekel, whatever it is, Daniel. You'll be given to the Persians and the Medians. Yeah, smart guy. Prophesied something that would come about 2,500 years later in the Habana Acts and the Masons, the coup of the Masons. So my son's case is a pretty big deal, and I wrote it to be a big deal and to cover everybody's cases. That's why the Fourth Crown Claim in Equity was why I codified and established the Fourth Crown of Law, affirming what our faith is, so that these heretics and baby traffickers and pedos will be brought to the law finally. I don't even know how many tens of thousands of years they've been doing this. I know for a fact that I can prove that they've been corrupting the temples since Egypt, with the law of the pharaohs, actually. So you're talking about a group of usurping evildoers that have existed for at least upwards to 35,000 years, who have just gone through time and usurped anything related to the rise of civilizations that humans have brought. And any type of order we bring, all they do is sit upon it and then manipulate it and keep it in chaos, so that our existence and our level of technology and everything is always tampered down, and or we destroy ourselves with civil wars that they facilitate, world wars that they're on all sides of, and they just sit and reap the benefits of it. You know, so IBM, Exxon, BP, and all those companies, Standard Oil, that were that sold on both sides of World War II. They also that's that private jurisdiction. They created the Havana Act so that the industries of the United States and all over the world could fund both sides of the war and make a mint, and then go in and steal all the babies and sell them to whoever they sell them to, because that's what their false temple practices have been since before Christ. And you know, that was just a small part of what Christ spoke about. But so I'm going to leave you with this tidbit of information. I'm sorry that it's been so long since I've done a video, but again, a lot of the information that I would speak to you about is national security sensitive, and I'm not going to disclose it and precipitate something that until other people have clearly done something to make it so bad that I have to correct what's happening, so you all understand. So in this course, I'm going to tell you that whatever they're telling you about the stock market is a big fat lie, and that it is on the verge of collapsing, because everyone now knows it's just a big fraud and everything is manipulated and it's all criminality. So namaste to you all. I am, hopefully this will stay up on YouTube. You never know with my censorship. I will definitely save this. I would rip it as soon as you can. I'll get about 300 hits off my YouTube channel and about 15,000 somewhere else. So please share this. Make this go far and wide, that there's proof, positive evidence that JP Morgan Chase, the Fed, and various instruments of international accord that were created post-Havana, under the Havana Acts, are enjoined in a massive attempt to defraud our treasury that I hold. It's in default, but I hold it, and I'm holding it so that they can't defraud it anymore, folks. And in fact, I've actually given directions to the IRS. They're on the hook because apparently H&R Block is a NGO, or is a subsidiary, privately funded subsidiary of IRS. So if the H&R Block verifies that a 1099 of a value of $104 billion was provided by JP Morgan Chase, and they're certifying the receipt of this amount of money to pay their taxes, what instrument did they produce for that? Where's this 1099? And if H&R Block was given that instrument, that means that the IRS should have my instrument. But they're not going to steal my intellectual property. They're not going to pay themselves to kidnap myself, my wife, my children. That's not fucking going to happen. Okay, so expect the market to be shit tomorrow as well. Okay, unless they take it completely off the general ledger and make it in a set aside and just let it run for a while we bring all the criminals. I mean, but they'll have to literally change the ledger proper for that to even happen. And right now, everything they're doing is still touching the general treasuries, and that's why it's a matter of national security, and why them blocking the service to the military for 7 to 10 days so that they could backroom deal and do insider trading for a week, which is what they do every time I put instruments into DC, by the way. That doesn't work either. I mean, people lost billions of dollars because of the vacancies of them interfering with instruments of negotiation reaching important agents of state that are there to help prevent such backdoor dealings from happening to begin with, more or less in a conspiracy to defraud the Treasury and to literally, J.P. Morgan Chase, when I show you the language of this, they think they own the territorial state, Ohio. They literally think it's their private property now, folks, because they seized my instrument that put a lien on it. They think they own it, because I guess they think they own me and all that I am, which is definitely not going to fly. So, peace be with you all. Be safe. Be prepared. Keep water in your gas tank. Keep food in your house. Keep backup water. Keep a small amount of cash available. I cannot speak to how things are going to go because at this point there is a disconnect between the DoD and reality because they've been obstructed from receiving stuff for so long, according to them, and they don't have much time to catch up. So namaste to all. Spread this far and wide, and let's hope that the word gets out because everybody else knows it. Why shouldn't you guys? Everybody else knows. Why shouldn't you? Namaste. Love you all. Be careful. Travel well.